A residential tenant must allow the home to be shown on a reasonable basis, with at least 48 hours. Notice. Facts. The single-family residence, which is rented to a tenant, is listed for sale. The listing agent wants to show the residence to a prospective buyer and gave the tenant 24 hours advance notice of the showing. Issue. Is a 24-hour advance notice sufficient? Answer. No. Discussion. A residential landlord has the right to enter the premises for, among other things, showing the premises to a prospective purchaser. CARS, paragraph 33, 1343A. However, except in an emergency, the landlord must give the tenant at least 2 days' notice with the intent to enter. Further, the entry into the dwelling must be done only at reasonable times. CARS, paragraph 33, 1343D. A residential tenant should complete the move-in. Form as quickly as possible issue. Does a residential tenant have 5 days to complete and return the move-in form to the landlord under the AAR Residential Lease Agreement? Answer. Pursuant to lines 272-74 of the AAR's Residential Lease Agreement, a tenant has 5 days beginning on the date of occupancy to complete and return the move-in form to the landlord. The tenant is therefore not required to complete the move-in form at the initial walkthrough. Please note, however, that this is a default term, and the time for completion of the move-in form could be altered by agreement of the parties. A tenant may park an unlicensed vehicle on the rented property. Facts. The current tenant in residential property has an unlicensed, unregistered, non-working vehicle on the property, and the owner wants it removed. It was listed on the rental application as a vehicle owned by the tenant that would be parked on the property. Issue. Can the landlord ask the tenant to remove the vehicle? Answer. See discussion. Discussion. If the tenant has access to a parking space with the leased property, then the tenant has the right to park a vehicle at the property. There are possibly local ordinances that address abandoned vehicles, and as long as the tenant is not violating local parking ordinances, etc., the tenant is not violating the lease agreement. The tenant is required, under the lease, to keep up the property. The tenant shall comply with the homeowners association or other rules and regulations and maintain the property in a clean and safe condition. As long as the tenant is complying with these guidelines, the tenant has not breached the lease. AC must comply with municipal ordinance. Facts. A tenant states that the AC is not functioning properly. The landlord had the system tested, and the unit was found to be running at proper capacity. The AC company advised the tenant that when the exterior temperature is 110 plus degrees outside, the consistent interior temperature of 77 degrees is expected and reasonable. The AC vendor states that, in extreme heat, the unit will never get to 65 degrees, as the tenant has requested. Issue. What is an acceptable temperature in the summer? Answer. See discussion. Discussion. Various municipalities have ordinances addressing this issue. For example, the City of Phoenix Ord. 39.5b, 1b, requires every rental housing unit where such systems are installed shall have cooling capable of safely cooling all habitable rooms, bathrooms, and flushing toilet rooms to a temperature no greater than 86 degrees Fahrenheit if cooled by evaporative cooling, or 82 degrees Fahrenheit if cooled by air conditioning. Thus, a landlord should check the municipal ordinances in each town, where they own a rental, to be certain of compliance. Accounting of security deposit may not be required. Facts. A property manager placed a tenant in the landlord's property. After the tenant failed to pay rent for several months, the landlord filed an action for eviction with the assistance of an attorney. The landlord obtained a judgment against the tenant, and the tenant was evicted. The landlord wants to claim all of the security deposit toward the amount owing from the judgment. Additionally, the tenant has left no forwarding address. Issue. Should the property manager provide an accounting of the security deposit to the tenant? Answer. See discussion. Discussion. Within 14 business days after the termination of the tenancy and delivery of possession and demand by the tenant is entitled to receive an itemized list of all security deposit deductions together with the amount due and payable to the tenant. ARS 33-1321-D. According to a strict reading of the statute, unless the tenant has made a demand for an accounting of the security deposit, the property manager does not necessarily need to provide an accounting. However, the best practice is for the property manager to send a final accounting to the last known address of the tenant, regardless of whether the tenant demanded an accounting. After filing bankruptcy, the tenant does not need consent of bankruptcy court to sign a new lease issue. The tenant owes his landlord $1,200 in back rent for an apartment at the time of filing bankruptcy. After filing bankruptcy, the tenant moves out and wants to sign a lease for a new apartment. Does the tenant need the permission of the bankruptcy court to sign a lease for a new apartment? Answer: no. The bankruptcy court generally does not have any control over the liabilities of a tenant, including signing a lease for a new apartment, that are incurred after the date of the bankruptcy filing. Note: the $1,200 in back rent, owed prior to filing bankruptcy, should be discharged in the bankruptcy proceeding. After lease signed, the landlord can still terminate lease. If tenant has bad credit issue. The landlord and tenant signed the AAR lease for a home on June 15th with an effective date of July 1st. The tenant gave the landlord $500 earnest money. On June 25th, the landlord learns that the tenant's credit is terrible, and the landlord no longer wants to rent the home to the tenant. The tenant has spent money to transfer the utilities, and the tenant has furnished notice to terminate the lease at the tenant's current home. Is the landlord entitled to terminate the AAR lease if the landlord learns that the tenant's credit is terrible? Answer: yes. Under lines 92-94 of the AAR lease, the landlord can terminate the lease prior to possession if the landlord learns that the tenant's credit is terrible. In other words, the AAR lease is contingent on the tenant's good credit. Note: the landlord is entitled to apply the $500 earnest money to any lost rent from July 1st until the landlord finds a new tenant. After the rental home is severely damaged by fire, the tenant has the right to terminate the lease issue. The rental home is severely damaged by fire. The tenant wants the landlord to pay for the tenant to stay in a hotel until the rental home is rebuilt. Is the landlord required to pay for the tenant's hotel expenses until the rental home is rebuilt? Answer: no. If a rental home is substantially damaged by fire, under ARS Par 33-1366, the tenant can immediately move out and furnish notice within 14 days to terminate the lease. After the lease is terminated, the tenant is entitled to the return of the security deposit.